the NITS team is also in discussion with the selected members of the Electoral Commission of Jamaica, the ECJ, to concretize what role they will play in the NERA. And until that is sorted out, we hope during the course of this week, by early next week, they will be able to return to the committee and indicate to the committee what role the electoral commissioners will play in the National Identification Authority. So that's just for the record. We can say to the public that the electoral commissioners are likely, that the select electoral commissioners, not the nominated members, the four selected commissioners will play a role in the national identification system. With that, having said that, we will have more information, if not later in the week, by early next week, when the NIDS team will be able to brief us on their discussion with the selected members of the ECJ. All right, having said that, I indicated by WhatsApp to all the members that we're going to ask the NIDS team to assist us as we go through clause by clause. In essence, I think Kamika, Warren, and Janelle, and the team itself will assist us with each clause to see what were the contentions, what are the concerns, generally the correspondence from the public. And then we have put that, they have put that on a matrix in association with Parliament. And so as we examine each clause, we can then sign off and we move on. So having said that, Kamika, I think you're going to be leading the clause by clause.
Good morning, Minister. Yes, I'll be assisting you with that this morning.
So,
all right, so I'm going to, yes, Minister?
No, as we go through, we are going to go from, as we say, we're doing clause 1, 3, 4, 7, okay. 8. I don't expect the first 3 will give us much difficulty, but we'll leave it to you. Just indicate to us, please. Members, please feel free to intervene whenever you like, okay? As Kamika, at the end of each clause, I will ask for comments, and then, but you can intervene during the commentary by Kamika. But immediately after she makes her comments on each clause, I will ask for members to indicate any concerns they may have, okay? Okay, over to you, Kamika.
Okay, thank you, Minister. All right, so basically what the team did was to look back through the different submissions, pick out the substantive submissions and make a summary. And here it is, we just utilize the same schedule that we had done before to indicate the different areas that had come up and what amendments would have been recommended. So for part, well, as it relates to the short title commencement, objects and application, with regard to clause 1, it's not recommended that there would be a particular change. Clause 3, there may be a change. 4, a change. 7 and 8, none. And 9, there are a few changes to be made there. I'm gonna go now into, so you would have received a very detailed matrix from the Parliament, and what we have done to save time is distill further to indicate specific areas that the committee would need to make a decision on. And the first one would be clause 1. I hope you can see properly. Just indicate if I need to do anything with my screen to make sure you see better.
Yeah.
Okay, good. So here we have clause 1, and what I have done, the summary of submissions, summary of responses, the committee's decision, and as you go across, you will see the details. So you can utilize this particular form for yourselves after. Right. So with the JFJ now, clause 1, the JFJ had asked that the bill be amended to indicate that NERA will only be operationalized after Data Protection Act comes into force. And the technical team's recommendation is that this isn't necessary because this is an administrative decision which can be achieved in another matter. So no necessary amendments to this clause to achieve that particular recommendation should the committee take it on. So I don't right.
Kamika, just a moment, just for the benefit of members, in discussion with the NIDS team and also in discussion with Minister Vaz and, and the Ministry of Science Technology, indicated to them that it's unlikely that the NERA will come into operation before the Data Protection Act and all the regulations are actually enforced. So this submission from Jamaicans for Justice is not necessary because administratively it will not bring into force the NIDS operation before the Data Protection Act comes into force. Is that right, Kamika?
Yes, Minister.
Chairman, if I may, I would suggest that we do not put the request as not being necessary, but I do agree that it is not for inclusion in the, but to remind that it's not so much an option as to which law predates which in terms of coming into effect, given the pronouncements of the court. So we have taken the decision to be guided by the courts without an appeal, and so this law will have to take effect after the data protection law is operationalized.
Okay, and just to confirm what you're saying, AG, we will ask Anila that this is a fundamental, in relation to clause 1, we will put that in the report to Parliament, okay? To make it clear. Okay, thanks, Camille.
All right. Okay, sir, let's go back over. And there was another recommendation or request by the DFG, and they had requested actually that, as you may be aware, the Data Protection Act has been enacted. However, it's not yet in force. And even after it is in force, the act actually inserted a 2-year grace period during which entities would be able to put in place all the measures. And during that 2-year grace period, the tenets of the law will not be applicable in terms of any breaches under that particular piece of legislation. And consequently, Jamaicans for Justice, the coalition that they led, asked that that 2-year grace period be not applied to the authority. And
we agreed to that.
Right, okay. So
that will also be in the report. Now, do we have to put that in the legislation? Should we put that in?
Right, so this would not be guided by the Chief Parliamentary Council, of course, but this would not usually, I believe, be amended at this particular part of the bill. She may choose to amend in the consequential amendment section to the Data Protection Act, but guided, of course, by the Chief Parliamentary Council as to how that will take place. Right. Now, clause 3, the JFJ, again, the coalition, requested that, okay, there were a few submissions where persons were concerned about the objects of the legislation. And one of the, they didn't believe that it stated clearly, for instance, the voluntary nature of the bill, as well as they were concerned about the object to prevent identity theft, and they believe that it should be reworded because the authority will not be able to achieve that objective, and that was JETS and BOJ. Accordingly, they requested that that object be modified to indicate something like to minimize identity theft. We, the technical team don't believe that that's necessary. The objects in legislation are aspirational concepts. The Chief Parliamentary Council, if you will recall, also indicated that that language was necessary to mirror the language utilized in the Data Protection Act in order to create that nexus for applicability on that particular area within the Data Protection Act. And she can indicate if I explained it correctly, but that was my understanding.
That's my understanding too, Kamiko.
All right.
The Joint Select Committee, do we agree that we keep prevent identity theft instead of what was suggested by a contributor that we should put to minimize identity theft? The reason suggested by both Kamiko and the CPC is that to prevent identity theft mirrors the language in the Data Protection Act. So can we agree that we keep this phrase, prevent identity theft, which is in subclause 3G? Is that okay, colleagues?
Sorry, Minister, you're saying that the language in NIDS is the same as in the data protection?
That is correct, Minister Williams.
Okay, all right.
So.
Supported also, Chairman.
All right, wonderful. So thanks, Kamiko. Were there any
All
other?
right. Yes, yes, Chair. There was another very important where the JFJ's coalition, pardon me, right. So the JFJ's coalition had also recommended that the committee insert an object to explicitly reference promoting and protecting human rights and the fundamental freedoms of all persons in a free and democratic society. The technical team had indicated that there is no need for that explicit reference because the legislation, all legislation in Jamaica is subject to the Constitution, and the Constitution already recognizes and protects human rights. However, a recommendation is being made. I'm not sure why you're not being able to see. Right. Can you still see?
You mean on the right to amend section?
Right here.
Yeah.
Right here.
Right.
Right. So it's too small?
Well, for me.
Oh, okay. All right. Let me try something else. All right. All right. Can you see now a little bit better? Right. All right. So it's not customary to indicate certain types of language. However, the technical team is recommending that the object to facilitate the recognition and protection of the legal identity of an individual could be inserted to further strengthen the piece of legislation and to plug that gap which certain contributors indicated they had an issue with. So persons, for instance, the Jambar had indicated that the objects were not totally clear to them as it seemed to focus quite a bit on the databases and not the
Kamiko, just 1 second. Anila, could you ask the technical team to let in Julian Robinson? He said he was on, but he got kicked off.
Oh.
Okay.
I'm back in, Chairman. I just
all right, good, Julian.
Chairman, may I just ask what would be the component part of the legal identity that is being put forward? Because this is an issue that is not settled yet. So what exactly is being contemplated by the technical team's submission or recommendation?
All right. Well, legal identity is important for an individual. It is one of the human rights. This bill is intended to, for the first time in Jamaica, actually put forward a unique identifiers to enable someone legal identity, unique identity to be recognized. Additionally, the state would also be indicating via the security mechanisms and because it is also necessary to protect someone's legal identity, that this particular piece of legislation, that's the main or one of the main reasons for this particular piece of legislation. So a particular individual would be able to be recognized as this particular, as person X, and that would be their legal identity within Jamaica and without Jamaica.
I don't think I probably was not clear. What are the component parts of legal identity? From the menu of the biographic. And
oh, okay. My apologies.
What exactly constitutes?
Sorry, AG, you're in and out. Sometimes I'm hearing you, sometimes AG?
CPC, is CPC on, Judith?
Yes, Chairman.
What's your view on that recommendation, CPC?
Well, I also queried what was meant by legal identity. There was another recommendation that referred to facilitating access to identification. I think that sets it out in a clearer way. So I would agree with that recommendation.
Which one?
Chair, it is, Chair. The JFJ had also indicated.
I'm not, Chairman, what exactly comprises legal identification under the law if we're setting out an objective to either access it or what was the other terminology?
I agree with you, AG. Why are we using the term legal identity or
Yes.
legal identification? Why not just identification?
Yes.
Oh, okay.
In other words, you know, identification. Why I agree with AG. This, you know, our term legal identification. I'm not too sure what that is myself.
Oh, okay. Okay. So the issue is the word legal.
Right. You can say the protection of the identity or access to identification. The next thing people are going to ask, what is moral identification?
There you go.
Okay.
Community identification.
Okay.
I just say identification.
Okay.
So I don't know, colleagues, and CPC, you favor CPC guide us here. What would be your preference?
Yes, I would prefer to simply refer to facilitating access to identification.
Okay.
Access to identification. So
Yes.
Warren, I am not denying that Warren, you want to just make that point which you indicated in writing about the United Nations concept of legal identification. Warren, you're on.
Yes, Chairman. I am just to say before Warren comes on that I am familiar with the UN concept of it, but there are also, well, let Warren.
Warren?
Thank you, Chairman, and good morning, everyone. Good morning, committee members. So initially, when we had the conversation about strengthening the bill specifically for identification, we were trying to find a globally recognized term to use, and we came across the United Nations operational definition of legal identity, hence we included same. We don't see any harm in using identification. So if the committee decides to use identification, that can also work in our context.
Yeah, I would agree with the AG. Just to use the term identification is much broader than the narrow term phrase legal identification. So the real issue here, though, CPC, is to put in one of the objects, whether it is to facilitate access to identification or
Is this, Mr. Chairman, sorry to interject,
Sure.
but just, is it to facilitate individual access to identification? I just wondering about the, if we are seeking to agree the exact language here, or if we are seeking to capture the essence of what the committee is agreeing to, and then of course CPC. Just checking if the fact of it being an individual's identification if it merits a mention, express mention.
Yeah, my recollection, it was a good point that JFJ was making, that the NERA should allow an individual to be able to say with this card, this is my identification. Isn't that right, Kamika? That's my understanding, you know.
Yes, sir, that was one of, yes.
And I think it makes a distinction between, one of these public queries that have been made regarding, a TRN being something that is
correct.
It's accessible by a company or, a business name or a person as an individual rather. And this is something which is only accessible to an individual who fits within the criteria.
So they put in us a very good point, that we are speaking about a unique identification of an individual, so that the object, under the NERA, a person can say, this is my identification. Okay? So I agree. Go ahead, AJ.
Not to be confused. So we're establishing the NERA. We're providing for enrollment of certain categories of persons. We're establishing databases. And we're providing for...
Members should know this is the usual chant of the AGs.
Okay. Still coming in.
My apology. And we're providing for identification to be assigned to enrolled persons. We're providing for the issuance of an identification card. We have some aims in relation to identity theft and fraud, identity fraud. And this one now is in relation to what?
It's basically for the individual to be able to say that with this card, my identity.
So let's not confuse it. Whomever I believe myself to be, it's not for me to verify for self, but it's in relation to others.
That is correct.
So what it is in relation to, I see committee agree to the insertion of an object regarding the concept of facilitation of an individual's access to identification. What does that mean?
Well, the way it was put broader by JFJ. Or what was the other phrase that was used?
So no, just the facilitation of the individual's access. So we're facilitating an individual's access to the database. What are we facilitating?
You're facilitating his ability to say that with this identification, this is who I am. This is my unique identification.
And that's why you're issuing the card. So
that is correct.
What other goal is not going to be achieved in respect of that issue, other than enrolling the person and then issuing them with a card that they can present?
Right. But the individual should be able to say, with this card, this is my name that represents me. So,
but why can the individual not say it upon being issued the card and in turn presenting it? Why does it require a separate object?
Well, no. The truth of the matter, AG, is that all that is happening is that you put it in objects because you're saying this is what it does. So I agree with you.
I don't agree with the recommendation.
Well, all that.
But it's a matter for the rest of the committee to indicate, because I think what it is seeking to do is already covered through the provisions of the law.
No, I'm not denying it is implied. But
it's already covered. It's already covered. If it's merely to say for the individual having been issued, having enrolled, firstly, voluntarily, and then having the process of enrollment is completed, you're issued the card. In turn, you use the card for whatever purpose that you are called upon to verify that you are who you say you are.
I support the Attorney General on this.
Go ahead, Ransom.
Yes, I agree with the Attorney General. I was just waiting for an opportunity, not to be, you know, but I'm happy to hear she says that. I don't see why it is necessary. When you put in additional words in a bill and an act, it has to be interpreted and often leads to confusion. I don't think it's necessary, and I don't think it should be put in. That's my view anyway. That's it, Minister.
In the view, Minister Johnson Smith, Minister Williams, remember what both AG and Senator Graham are saying is that it is implied already. Do we need to express it? Is that my understanding, AG and Senator Graham?
Well, not to use your words of whether it's implied. I'm saying what they're seeking to do with the recommendation is already provided for in the law. So okay. I use implied or express. I deliberately didn't use those words.
I am Chairman.
Yes.
I must say that while I agree 100% with the principle of being careful about adding language into bills, which of course require interpretation at later stages, I must say that on this particular issue, I am not clear on what the harm would be when I read through objects, through the objects in clause 3, which speaks, the word identification appears several times in respect of databases and the number and the card and information. But the actual fundamental aim of the legislation, the fundamental, and perhaps this is why the AG and Senator Graham view it as a given, but the very fundamental aim of this act of this bill is to allow for individuals access to identification. That has been to unique identification, their ability to be uniquely identified. And I am not sure what the harm would be or what complication that would be once one removes the word legal, which raised the AG's legitimate query earlier regarding what exactly would we mean by that and what other type of identification would you wish to, could you then say exists? But I didn't see the harm in it, and I will be guided by a majority view, of course, but I thought that it would have helped clarify by stating this very, we take it as a given, we take it as as understood because we have been working with this aim for so long. But the public has raised the question, why this and why not a TRN, why not something else? And I therefore didn't see the loss in it. But
the other thing too, if I might support you a bit too, without making a decision on my part, that bear in mind the individual should be able to say to any third party, business person, this is my card, it is my unique individual identification, and therefore you must accept it as being my identification.
May I ask then, Chairman, if we look at clause 3F, where one of the objectives stated is a provision for the issue of a national identification card to each enrolled person. We need to just expand that a little in respect of what the enrolled person would then do with the card. So you do the card, and then it is for use for what? Verification of their identification, whatever. If we look on what is there, because it doesn't stand on its own. You issue it so that it can be used, because E speaks to the provision for the characteristics, assignment, and use of the unique NIN to be assigned to each person, and then for the issue of the card to the enrolled person. So the card is to be used for what purpose?
Right. So
Well, that's just it. Under 16, it actually doesn't say, it doesn't speak to the use of the card, you know, it speaks to then the duties in respect of the card, and it speaks to, because when you look back at the definition of the national identification card, it's a card issued under 16. And under 16, it speaks to the fact that it is deemed to be a public document for the purposes of Evidence Act. It's, you know, the authority should keep a record. It must not be transferred, and it must not be treated as conferring any right of citizenship, and you must have safe custody and all of these duties, but it doesn't actually say that it allows you to present it as a form of identity.
Maybe that is where we could look at providing for the clarity in respect of its use.
But AG, you have a good point there in relation to 3F. Merely providing the national identification card to each enrolled individual. The point we're discussing, that's a possibility that we could add something to that to say that it represents the individual's unique identification.
All right, Chairman. Perhaps we could, when we get to 16, could make the decision as to
whether we adjust.
What else could go there, or where the adjustment needs to be made.
No problem, no problem. So bear that in mind, Jamaica and its team, and also CPC. Maybe CPC can.
So the committee is agreeing for the insertion of a provision which speaks to the use of the card by the individual to whom it has been issued.
That is correct. In other words,
if that reflects the consensus, right?
So either an adjustment to 3, or when we get to 16.
The use of the card by the enrolled person. Yes.
Wonderful. Thanks, AG.
Okay.
Chair, I have my hand up, but
sure,
before we do that, could you take a look at 17?
No, actually you're right, you know.
Yes.
Actually, you're right.
That is what I had thought. Thank you for the reminder of the provision, Senator Scott. That is what I thought when I initially said that. Thank you. Yes.
Right. Yes. Thank you. Yes. I thought that made it absolutely clear.
Yes. Thank you. Thank you for that reminder. Yes. Thank you so much. Because that is what I was grappling with in terms of the suggestion when I said that it was already provided for. Thank you so much. Yes.
Yes, Kamika and Warren, I hope you see that point. I think 17A clears up everything we've been doing.
Yes, Minister, brilliant point. I sent a message also in the chat earlier.
Okay.
About the proof of identity. Great.
So no amendment is necessary because of that. Thanks, Senator Scott Motley. Kamika, anything else on 3?
No, sir.
All right. So
Chairman, may I suggest that we look at each of the stated objectives just to ensure that the language captures adequately what we're seeking to do with the law. It doesn't delay us much, because I do recall, in another place.
All right.
Just quickly.
Could you just read the objects in 3 quickly for me? Kamika, go ahead.
Minister.
Yes.
I realize that I'm a latecomer, but the committee had discussed why it is necessary to put in a clause setting out at all, right?
Go ahead. You broke up there.
Why it is necessary to have a separate clause. I have seen it from time to time in legislation, but personally, I don't like it. That's why I want to know if we had discussed that principle. Why is it necessary to have an objects clause? Bearing in mind that the bill itself, when read, will declare its object. And if it is that you have an object, you have an object in another provision, which is not in the objects clause, what are we supposed to do with it? I just wondered if you had asked if that was asked, and what is the answer?
Senator Braham, Mr. Chairman, just before you come, you know that this has been a thorny issue in our highest courts in respect of whether provisions are covered and when they become thorny. So I too share that view generally. I think though, because this piece of legislation was breaking new ground, on a matter that has been discussed, that had been discussed repeatedly, the decision was taken to clearly set out what the law was seeking to do. But even so, it's been a little problematic to sufficiently and succinctly capture what the law is seeking to do beyond the establishment of the NERA and the enrollment of persons and the establishment of the databases. But yes, Chairman can probably shed some light on other members.
The truth of the matter, Senator Brim, it's my understanding it is not unusual, in most legislation that as AGC is breaking new ground to say exactly what the legislation hopes to achieve. Yep. So that. I think basically that's why in most sort of innovative areas of law, we usually put in the objects.
Well, what I would say, Chairman, is that in practice, these object clauses, when you have to interpret the whole bill, tend to create more difficulties than help.
Yes, yes.
I personally would leave out the object clause. That's the object clause, because the bill, the legislation, when read, is supposed to declare its object. So if you have an object that is not covered in the bill, what do you do? And vice versa. Sometimes it happens, and you'll be surprised to know how, when people sit down to study these things, how they come up with arguments that may be accepted by a court.
Yeah.
I don't say anything more on that, because I know that.
Well, I don't know. It is something for the committee members to consider whether, in fact, we need clause 3. It's something that it's the first time it's been, we're thinking about it, Senator Braham. But we can, I don't think we should make a decision now. Let's think about it, okay? And we can come back to it later on. So put clause 3, Kamika, as something to be examined again as we go through the rest of the bill. Okay, Kamika?
Yes, sir.
All right, so let's move to clause 4 now then. Sorry, yes, clause 4.
All right, sir.
Mm-hmm.
Right, so the application, there were several different submissions made on this. JAMPRO and PIOJ were of the opinion that the definition of citizen was not clear. During the deliberations, citizen, it was indicated that citizen would be defined within the citizenship framework of Jamaica, meaning it's by birth, naturalization, descent. Specifically, JAMPRO had wanted to know whether or not, PIOJ had wanted to find out whether or not dual citizens would be captured within this definition. And the technical team's recommendation is that it doesn't need to be defined and that dual citizens would definitely be included once you're a citizen. Once you're a citizen, whether or not you have other citizenship in the world, you would still be able to obtain, to be enrolled in the system. So that was one of the issues.
My recollection is that it was cleared up by CPC. That citizen says what it means. If you're a citizen of Jamaica, then you're eligible, regardless of whether you're a citizen of another country. Okay?
Right, sir. The next issue was MNS had significant difficulties with the phrase ordinarily resident, and they didn't believe it accorded within the framework of residency in our immigration law. And they recommended that the word resident be utilized instead. And this had been referred to the CPC, and I believe we had come to the committee had come to the conclusion that ordinarily resident was appropriate within this framework.
Sorry, Ms. Facey,
Go ahead.
could you elaborate a bit more on what MNS had in mind, please?
Right, sir. MNS had, let me just find that particular, so I can read it directly for you. Let me search for it on my system. So they are apparently, sir, amending. Right, so they are currently in the process of amending the Immigration Restriction Commonwealth Citizens Bill, as well as the Aliens Bill. So the exact wording that they presented was that the definition of ordinarily resident at clause 4.4a doesn't accord with the proposed definition in those two bills, nor does it accord with the meaning in other jurisdictions or within immigration policy. So they indicated that the Aliens Bill is going to be proposing that the term is applied to persons who are lawfully and continuously resident in Jamaica for 3 or more years, or where the person, or rather Jamaica is the country of the person's permanent abode, even if the person is temporarily absent. They further recommended that the term ordinarily resident shouldn't apply in instances where a person resides in the country for a special or temporary purpose. That's what they had to say on that issue. So they went on to say, for the avoidance of doubt, they proposed that the term ordinarily resident not be used, considering the specific meaning of the term aforementioned. And they recommended that the term resident be used in its place with a specific time period requirement that's already in the bill of 6 months or more preceding the date of enrollment. Right. However,
sorry, Ms. Facey, you're clarifying that the MNS had presented 2 bills.
Right, exactly. They're talking about bills.
Two bills that are to go before the House. So these are matters for which Cabinet had approved drafting instructions for, in accordance with change in policy positions and legal positions.
Well, we don't know whether or not, we don't know the status of the bill, whether or not this has reached there. Is it that you are saying that that is the status of the bill?
No, I don't know what it is that was presented to you. But Chairman, just having regard to the process by which laws are made, laws are amended, we may have to check those issues elsewhere and come back to the committee.
Right. In other words, Jamaica, we have to touch base with CPC and also with MNS so that we adjust, if necessary, phrase whether we use the term resident or ordinarily resident.
We just need to look back on the...
Sure, CPC.
I was just wondering why that would be necessary, because my understanding was that this particular bill was inserting its own definition of what would constitute ordinarily resident for the purposes of this legislation, and that would be based on policy considerations as to what would, in the period of stay, that would entitle somebody to be able to apply for a national identification card and to enroll in the system. So I'm not sure that what is being done under the Aliens Act or the Immigration Restriction Commonwealth Citizens Act would necessarily have a bearing on that.
Right, Chairman. That is why I was seeking the clarification if the intention, based on what Cabinet had approved, would have been to affect the scheme of this law. But as the CPC has said, for the purpose of this law, for the purpose of being eligible, because this clause is dealing with the eligibility for enrollment. And we have a two-limb eligibility. Those who are citizens of Jamaica, in accordance with our citizenship law, nationality law, chapter 2 of the Constitution, and the ordinary laws that flow from that.
Right.
Respect of those who are ordinary resident. And the purpose for the definition is to clarify it for the purpose of this law.
Right. So, colleagues, members of the Joint Select Committee, if you agree with what CPC and AG saying, which clearly is what is intended, can we just agree that what it remains, and so what MNS is doing it's not inconsistent with what MNS is doing? So we should just accept, for the purpose of the needs, that the definition of ordinarily resident remains. Okay? Is that agreed, everyone?
Chairman, may I just suggest, since we will be coming back, to also make a note to just seek some clarification.
My hand is up, Chairman.
Yes.
Right, no problem. Absolutely. All right, thanks again. Can we move then? Can we?
Chairman.
Member Hill,
may I ask something?
Sure, Senator Hill, you're on.
Yes, I have a question. The wording here says individuals ordinarily resident in Jamaica. Does that mean that they've been ordinarily resident in Jamaica and left?
And look at subclause 4, Senator Hill. What CPC is saying, you can get a different definition for ordinarily residency in the Aliens and Immigration Act. But for this, what it says in section 4.4, for the purposes of subsection 1B, ordinary resident is defined as stated in subsection 4.4. Okay?
Is stated as where?
Subsection
Chairman? Subsection 4.4?
Right.
For the purpose of 1B, individual, an individual is ordinarily resident in Jamaica if the individual A has resided in Jamaica for a continuous period of not less than 6 months immediately preceding the date of application for enrollment of the individual, or B is in Jamaica pursuant to a grant of leave to enter and remain in Jamaica under any law concerning aliens or immigration for the purpose of study. Chairman, just to say that the first, I'm wondering if it is the second limb of it. The second limb will naturally fall under the aliens and immigration law scheme.
I'm still on the floor, isn't it? I have a question still.
Member Hill, I'm so sorry.
Thank you. Thank you. So what it says for 4.4a, has resided in Jamaica for a continuous period of not less than 6 months immediately preceding the date of application. Now, all the legal luminaries, in my mind, immediately preceding is not defined. And therefore I could leave Jamaica, maybe not even coming back, but I was resident here immediately before. And how is that immediately before defined? And shouldn't the person be resident in Jamaica when they're applying? I leave that on the table. I move on. Consider it.
I agree that it's a matter for the administrators to determine, Senator Hill. You know what?
Sorry, Chairman. If Senator Hill's point is taken, I think what he's saying is that it would read, subject, of course, to the CPC's language, if the individual is a resident in Jamaica at the time of application and has resided in Jamaica for a continuous period of not less than 6 months. So it's both that they are resident at the time and also have been resident.
Thank you.
Also have resided for a continuous period.
Right.
Period of 6 months. Thank you.
You apply because you were here and then you skip out and gone.
Right. I mean, I would imagine, Senator Hill, the administrators would be checking on the movements and travel arrangements of the individuals before admitting that person to enrollment. So if the
I don't like imagining, since we're drafting a bill, let's be clear.
No, I agree. But you know, nothing will be exact. So the administrators will have to interpret it at a certain point to say if the individual was resident 2 months, he went back home for a week or 2 weeks.
No, Chairman, I'm saying
Chair,
we should not. I'm saying, Chairman, we should not do that. The administrators are not supposed to do that. If you were resident here when you're applying, if you're not resident here, you can't apply if you're not a citizen. That's my view, but we leave it alone. You guys can
ordinarily resident. Ordinarily resident, mean that you are a resident here.
Mm-hmm. Sorry, go ahead, Kamika.
Just to indicate, Chair, that it does that the clause does say for a continuous period, not a broken period. So the person who leaves Jamaica, that period would be broken and they would have to restart that time, counting that time from the moment he comes back or she comes back into the island. I don't know if that assists Senator Hill.
So Senator Hill, my understanding from what Kamika is saying, if it is not a continuous period when they apply, and also that they're here in Jamaica, the likelihood is that they may not be enrolled. Is that my understanding, Kamika?
Right, sir. So the clause states they have resided in Jamaica for a continuous period of at least 6 months immediately preceding the date of application. So the date of application, they would count back 6 months from that.
Senator Hill's point is a little more nuanced than that. Senator Hill is saying you may have someone who has been resident in Jamaica for a continuous period of not less than 6 months. That person on that basis has made an application to be enrolled, but having done that, they then leave Jamaica and are no longer resident in Jamaica. So that if it is that you are resident in Jamaica, ordinarily resident in Jamaica, not only when you live in Jamaica, but also when you have lived in Jamaica for a continuous period of not less than 6 months, immediately preceding the time of counting.
The truth is,
the CPC can indicate whether the language is sufficient to take care of it or other clarification, but who understand the point that Senator Hill made?
Right, okay. Any comments, CPC?
Yes, I understand the point, but I don't think that it could be phrased differently because the period does say, it says immediately, so it's right up until the date of application. And to include something speaking about residing in Jamaica at the time of the application, I think would create problems, for example, for people who might go abroad, who do reside in Jamaica and might be temporarily abroad while their application is being processed. So I don't think that it would aid us to further complicate the provision.
All right. Before we move.
Funnily enough, Chairman, that's exactly the reason why I stated. Because I really believe that if you're not a citizen of Jamaica, you must be resident in Jamaica when you apply.
Absolutely. No, I agree with that.
So I move on. You technical legal scholars can deal with that. I rest my point, Chairman. Move on.
Minister. Thanks, Senator Hill.
Minister, the CP, the Sergeant's hand is up. Mine is up, but Sergeant's hand been up for a while, sir.
I can't see it for one reason or another on my computer. Please intervene. Go ahead.
Go ahead, Marlene.
Thank you.
Sir SG.
Thank you. Morning, Chair, morning, colleagues. I just had a comment on the MNS's proposal. As far as I understand it, there is no intention to amend the Interpretation Act to include a definition of ordinarily resident. I say that because that is an act that can have general application across all laws. If they are making an amendment to their own laws to define ordinarily resident, it will only be applicable for those laws. This is important because the term ordinarily resident is used in other laws, including tax laws, and the manner and the way in which it is defined in other laws is consistent with what's in the NIDS bill. So I would just like the committee to take that into consideration.
Thanks very much, SG. At least it clears up a number of points. Okay, thanks again.
Minister, Ms. Wilkins, subject to Ms. Wilkins, I have one question or clarification.
Sure.
Solgen made the point I was going to make very well, so I will I'll take my hand down. Thank you. Thanks, Abraham.
Okay, Minister, you know that Jamaica is a place where some of the strangest things happen. For example, recently I had to deal with a lady who appeared to have come to Jamaica at about 4 years old. It could have been a part of a trafficking situation, and she was given to a lady, but sufficient to say that she's now 35 years old. And up to then, she had no papers, but she has been living in Jamaica for more than 30 years with children, etc., etc. Having said that then, I asked the question in 4, is it 4? Yes, 4.4. It says, for the purpose of this section, 1B, an individual is ordinarily resident in Jamaica if the individual A has resided in Jamaica for a continuous period, and it continues. And B says, is in Jamaica pursuant to a grant of leave to enter and remain in Jamaica. So the question I'm asking, is it too much to wonder what exactly it means to reside? Is it?
No, but Senator Graham, those two clauses, subclauses are disjunctive.
I understand they are. Yeah. I agree. But what I'm saying, B clearly makes it clear that you have to legally be in Jamaica.
No.
B and A doesn't say that. It just simply says resided in Jamaica. I just wondered if there's any room for any argument. Could my lady come under B, A?
My view is yes.
But not under B.
Not under B. But just my 30-year lady who has no Jamaican papers, but she has been living here for 30 years. I must say that the Minister of Security exercises discretion under another act and dealt with her situation after police investigation. But I'm just saying, up to recently, she was living basically here without papers. Could she apply under A? Is that the intention?
I suspect the answer is yes, if she can.
Minister, may I just interject here that the status of a person who presents themselves for enrollment is the status as determined by PICA. So that individual would not merely be enrolled simply because they say they were resident here for X period of time. There must be from PICA a determination as to their immigration status, and the NERA would follow what PICA has determined.
Okay.
Chairman?
Yes.
May I speak?
Sure, go ahead.
Okay, Chairman, I just want to bring your attention to 16.5. Says the issue of a national identification card to an individual shall not be treated as conferring any rights of citizenship on or proof of the domicile of an individual. So I'm not sure if that would be relevant. Just a point.
It would be, because it's just the card is just to identify the person.
So having regard to what I have said, and I understand it doesn't confer citizenship, but using that situation I've told you with somebody living here and have nowhere to go, is it a situation that we should contemplate that somebody be given some kind of limited discretion?
What do you mean by that? What do you mean by that, Senator Graham?
Let us assume that 4A is dealing with somebody who is lawfully resident here, meaning that they get all the papers, that 4A and B mean the same. meaning that you have to be lawfully resident here. You do find some strange things. And as I said, you may have somebody who is here and has been here a very long time. Should that person be entitled to apply? Should we want to know? Is the purpose of the NIDS basically to ensure that we know of everybody who is in Jamaica? And should the minister or the NIDS authority be having a discretion in a limited circumstance to issue a card when you don't qualify under A or B, assuming that A means that law, you must be lawfully resident?
I don't see how there could be any other opening, Senator Braham, to give you a card. You're either a citizen of Jamaica or you're ordinarily resident here.
Very well.
I can't see any, I can't see how someone who is a refugee here, who has, who is not known and has no status, as Nadine said, without immigration proof, how they could actually get a card.
Well, but they are here and they have benefited from the system. All right, no problem. Thank you.
All right, no problem.
Senator Brigham, if I may, through you, Chair.
Yes.
Clause 12 indicates that the authority may request certain documents for verifying the identity information of someone. So the person's identity information has to be verified. So whatever they present in terms of their name, date of birth, etc., would have to be verified by a birth certificate or a passport prior to.
Again, Kamiko, before we move on to 7 and 8, which should take us
Sorry, Chairman, if I may though, I have my hand up.
Sure.
Just to say, I think there should be some more consideration given to the provision, because rules of interpretation are you can always find a rule of interpretation for what you want. The fact that we have specified in B that the person must have been granted leave under a law, but we did not specify it in 4A, somebody could try to say that it's applicable only under B and not under A. I'm suggesting that maybe there should be some consideration given to ensuring that that whole aspect of granting leave under a law be placed in a manner that it governs both A and B for consideration.
CPC, we ask CPC to look at it then.
Chair, well, one would need to make a determination first whether that was in fact the intention, because having regard to the provision in 16 that Mr. Vernon drew our attention to, I would submit that 14.4a does contemplate a person who is not lawfully resident in Jamaica actually applying for the card. Somebody who, for example, is a refugee and who has not yet had their status properly determined. So if it would have to be clarified whether, as a matter of policy, those persons are to be excluded from eligibility before we can determine what is the appropriate wording for the provision.
Chairman, just to remind, part of the aim of the law is to ensure that we can account for persons within the jurisdiction, and those who perhaps would not have had any other form of identification can choose to come in, provided they can supply the information requested. But it's an important clarity that is being sought. Is it the intention of the law to make eligible for enrollment persons who are in Jamaica unlawfully, but have been here for an extended period of time?
That is a policy decision that the NIDS team we ask for some clarification. Discuss it, please, members of the NIDS team, because what is being discussed is that apart from citizens and who are lawfully resident here, is any intention to give an identification to persons who are here, you know, for whatever reason, refugee status or unlawfully find themselves in Jamaica.
Is that a cabinet policy decision though, Chair,
Well,
not just the technical team or for advice by the technical team? Because I don't believe the issue had come up in the way that it is coming up now for consideration. I'm not recalling. Put it this way.
Minister, as you deliberate, to remember the true story I told. That's all I would ask you to do. Bear in mind, what I say to you is actually a very true story.
No, I understand. I understand, Senator, and that is something that we need to discuss, you know, at various levels, including in Parliament, when that report goes forward.
Chairman, I have my hand up.
Sure, Senator Hill.
I have a concern, Chairman, in that while we concentrate a great deal, as we must, on the biometrics and what persons, what their identification, personal identification will be used for and how it can be released, we should be careful that we're not allowing NIDS to allow persons to enter into the benefits of being a citizen and or a legal resident in Jamaica by mistake. So I believe 4 must be very clear and specific. This is very vital for those, because the state, that this person is going to have a link to the state, and the state is going to have a link to the person to provide benefits and so on. So I don't think there should be, I think the Solicitor General's comment is vital and must be clear. And the AG said, did this come from Cabinet? And I'm not sure that Cabinet's position on the policy arrangement is as clear as we need it to be, and NIDS cannot be a sort of backdoor to get benefit in. You must be properly registered or be a citizen.
Chairman, through you, just as a follow-up to Member Hill's point, since we know the process by which policy is settled, should we just formulate this question to be clarified in that appropriate forum, and then we come back to...
I think you're right, AG. We'll get back to it, and
yes,
the clarification to 4, we will with AG, okay?
So is the intention to have the law broad enough to make eligible for enrollment persons who have been in Jamaica for an extended period of time illegally?
Fine.
All right.
So that's something that needs to be clarified.
We will clarify it in the policy.
Before we sign off on clause 4, we will have that clarified. Okay, AG and Senator Hill.
Minister,
thank you, Chairman.
All right.
Minister, this is Nadine. May I just interject that in as far as my involvement in the development of the policy went, it was never intended that a person who has not been recognized by PICO as having a right to be in Jamaica under whatever category would be eligible for enrollment.
All right. So Nadine, we just want to be assured that that is the position, that anyone who is not here lawfully cannot get it. Okay.
Well, Senator Hill is correct. That was not put to the Cabinet. He's quite correct about that, because that was never contemplated.
So that is something we just want to confirm.
Yes, I still would ask that the Cabinet consider whether the minister or somebody shouldn't have some limited leeway to it, because the NIDS, as somebody said, is a recognition of persons who are here.
Right.
And whether some leeway in a special situation. That's all I'm saying.
Okay, no, and I agree with you, Senator Graham. I mean, it needs to be clarified, okay?
So, may I just say that there is a provision for the minister. The Minister of National Security does have a facility where he can consider a person's circumstances and grant them different levels of
residency status.
Yes, there is. So that person would have to have done all of that. in order for them to present themselves to the NERA for enrollment.
Okay, but
and that's where it should reside, and not at having received the card. You have this benefit by almost default.
So to make, all I'm really saying, colleagues, let us just get a clarification and we will confirm that in due course, okay? By next week. So it's a matter that we'll discuss elsewhere. Okay?
Chairman, there is one other issue I will seek your guidance and the committee's indulgence on. Shall we reserve in respect of clause 3 for us to just come back to the committee with some clarification in respect of verification process of persons who are enrolled?
Sure.
It as vaguely as that, but I just wanted the record to show so that when we come back for deliberation in respect of clauses 3 and 4.
No problem. No problem. All right. We're running out of time, but I think we could do sections 7 and 8 if possible. There's 2 short sections. Just to bring members up to date, we're not doing 5 and 6 at this time because discussions is taking place between the NIDS team and the select members of the ECJ to determine the role that the ECJ or the select members of the ECJ would play the governance structure of the NERA. I mentioned that at the beginning. So, Kamika, we go to 7.
Okay, Chair. With regard to 7, this is the Ministerial Directions Clause. JFJ and the PSOJ recommended removal of this clause to limit political interference at operational level, as well as to clarify the reporting relationship between the authority and the minister. And as you just indicated, Minister, the committee is reviewing the governance structure to address the ambiguity in reporting relationships. However, the recommendation is not to remove this clause. It's a clause that is useful in legislation. It represents the conduit for policy directives from the cabinet through the minister to the government's operational arm, and the recommendation is that it be retained in its current format.
So just to say, Chairman, that to the extent that the governance framework is being reviewed, you may wish to clarify to whom the policy directions may be given. But for the listening public who continue to express suspicion around the giving of directions by a minister, it is important that they understand the constitutional framework, that the minister with responsibility would be a member of the cabinet, and the cabinet is the principal instrument of policy that is responsible to the parliament for the general direction of government. And so there is nothing untoward the giving of policy directions. I hear the comment being made from time to time, as if there is the desire to delegitimize a democratically elected government. We appreciate and understand concerns about partisan tinkering, but though that is not the same as the legitimate giving of policy direction in respect of subject matters.
Absolutely, AG.
Nothing untoward, nothing illicit, nothing immoral about it. And it is, time that we engage the public who continue to, for understandable reason, heap suspicion. But we can't have it always.
Apart from that, AG, the executive has to play a role in policy directions. Okay, so that clause, as I see it, is subject to tweeting depending on the governance structure.
Yes.
It has to be a similar clause where direction must come from the executive. Okay?
Chairman?
Yes, Senator.
I see Senator Scott Motley's hand is up. I'll go after her.
Senator Scott Motley, please go ahead. Unfortunately, I'm at home, so I have not been able to see from my computer when hands are up. It will change tomorrow when I will be in office. Okay. Go ahead, Scott Martin.
Sorry, I'm trying to unmute. I was of the view, Chairman, that if we were looking at the governance structure, that we shouldn't take the items separately. Okay. I thought we would have looked at the overall structure as one block so that we would have it in, we would be able to scrutinize all the different provisions to say what is applicable and what is not applicable. I didn't feel that it was, that we were going to be discussing them out of context. And I wonder if we couldn't do it in that manner rather than clause by clause separately as they appear.
Well,
am I?
No,
yes, Chairman.
Senator Scott Motley, save and accept that I thought 8 was on its own, but it may, as you're quite right to say, it may be affected by the governance structure. So what we could do, Jamaica, 7, it should not detain us that long when we do the governance structure. So I think we could leave 7, 8. I think 8 is okay. I mean, the cooperation with other bodies. So there should be no difficulty between the cooperation in 8. So we can leave 7 to return. So 5, 6, and 7, Jamaica, we will discuss when we look at the governance structure. Okay?
Very well, Chairman. Thank you.
All right.
The cooperation clause for certain of the
one second.
Oh, go ahead, Senator Hill. Sorry, Senator Hill.
Yeah. Yes, Chairman and colleagues, I want to reemphasize the point made by the AG and put it even a little bit more pithily. I want to make sure that my Jamaican colleague citizens understand that the very basis of our democracy is that we elect the people who must govern us so that we can throw them out if they don't govern right when the next time comes for an election. I am very wary, and I must encourage my Jamaican citizen colleagues to be very wary of handing a great deal of power to unelected people, whether those be at the Bank of Jamaica. As when I piloted the bill through the Senate, I was very clear. I believe the Bank of Jamaica must be independent, but they must be terribly transparent and accountable. So, but certain powers must not be downloaded to unelected people. And the elected persons in cabinet, where the executive decisions are made, must in the end have influence and very often must also have the final policy say. So I want to make sure that I say that as an ordinary countryman from St. Elizabeth.
All right, thank you, Senator Hill. And that will come up when we look at the governance structure. All right, thanks. So Jamaica, just go through 8, which is the last section we're going to do before we sign off. Jamaica?
Right, the 2 issues that came up, the 2 major issues were that clarity was required by several persons and entities which submitted, and they indicated that the parameters of cooperation should be made clear. For instance, to address the issue, clarifying matters that can be covered within these cooperation documents, and whether or not there would be other agreements, for instance, underlying this particular cooperation clause. Additionally, the public defender was of the view that the cooperation indicated in this clause was really data sharing, and the requirement of reciprocal cooperation was not necessary to achieve the bill's objectives. So she believed that it was actually in intrusive or could become intrusive. And the response from the technical team had been to indicate that the policy intent of clause 8 was just to facilitate the proper discharge of the functions of the authority. Data sharing, if we would call it that loosely, which takes place would be solely to ensure that an individual's records are accurate. And of course, that would require the individual's consent. There may be other reasons for cooperation to ensure the proper administration of the bill. However, if the committee, if more precision would result in the removal of this uncertainty, then the technical team would have no objection to that, subject to the Chief Parliamentary Council.
Chairman, just to state my own view, or Senator Member Braham, you may go ahead. Through you, Chairman.
Yeah, go ahead.
Yes.
I would say, and members, that that section will be interpreted in the context of the entire bill. What I'm afraid of is that, again, it is very difficult to legislate for every circumstance. And so you go now and put in a whole host of things under circumstances you can cooperate. And then a legitimate issue comes up that you need to cooperate. You have to go and amend the bill before you can. So that any proper interpretation of the section must be that it has to be within the context of the other provisions and the other authorities and the purposes that are set out there. I personally would leave it. I think that that amendment is born of suspicion.
Right.
To be suspicious, but at the same time, we can't tie up the hands of the agent unnecessarily.
So you see the bill as acceptable as it is, Senator Braham?
As it is. I have no difficulty with it.
All right. Thanks, Senator Braham. AG? AG, you're
I'm so sorry. Right. So the provision is cooperation in the exercise of its function and the implementation of the provision of the Act. It is in that context that the cooperation is being done. I'm, however, not averse for a little more precision in respect of, well, if it is that it's the data sharing, but just bear in mind that the cooperation is for the purpose of the carrying out of the functions and the implementation. It's really the point I wanted to.
That's the main point, AG. And I can see, AG, your bell is telling us it's 10 o'clock. Your clock is telling us it's 10 o'clock.
Yes.
And I promise everyone we're going to sign off at 10 o'clock. So we're going to sign off until 8:30 tomorrow morning, when we will do any clarification needed, but also we start with clause 9 to 16. Okay, Kamika?
Okay, sir. So the committee's decision here is to retain the clause.
As it is.
I would like to reserve on that, please.
Okay,
I would like
all right.
some further discussion when we return.
Okay.
We can return to it tomorrow morning. Thanks, everyone. Thanks for being with us this morning. Tomorrow morning, we start again at 8:30. And we try to sign off before 10, but definitely at 10. Thanks, everybody.
Thanks, Chairman.
Good, thanks.